Testing, testing, 1, 2, 3. Am I coming through okay?
Yes, it works. Perfect.
Great. I'm just going to double check that it's easy.
How about now? Can you hear me okay now?
Yes, we can hear you.
Okay. And how do I screen share?
You should be able to screen share. At the bottom of the screen.
Oh, here.
There is a.
You know, I'm going to switch mice because I think my mouse is actually acting up here. I'm clicking, and half the time it's not doing anything. Yeah, there we go. So can you see the slideshow there?
Yes, yes, we can see your slides.
Okay. And then if I switch, can you see the blocks interface there?
Yes.
Great.
Yes.
Perfect. Okay.
Perfect.
I'm all set. Should I stay connected or should I exit the stage, as it were?
You can stay, and I will hide you when you're not the speaker.
Perfect. Okay, sounds good. I'll just mute in the meantime.
here it's unmuted. The first one to mute it, and once again to unmute it. But here it's on. Okay. It should be good. It's unmuted. It's on.
Testing. Hello? All right.
I see.
Uh, I don't know, you tell me.
Yeah, can you go back? You should try this in the display here.
Yeah, it doesn't detect the external display. But it worked with my Mac, so I know the adapter is good. Unless someone destroyed my adapter.
I think I just got it. Uh, it probably has one on the website. It's probably called Federal Civil Procedure in the Lien Proof Assistant. In the Lien Proof Assistant.
Hello, everyone.
Hello?
Is this mic on? Okay. Everyone can hear me, right? Okay, so we're entering into our final session, everyone, with 4 more talks. And we're going to begin with a keynote from Chris Bailey from the, it's Chris Bailey, right?
Yes, yeah, thank
Excellent. Esquire?
you. Not yet.
Okay, I don't know what that means, so. From the Illinois College of Law, and he'll be talking about encoding civil procedure in the lien proof assistant.
Hell yeah.
Is that right? Great. So let's hear it for Chris Bailey.
Thank you. That's thank you. I know, I'm just kidding. 45 minutes is a very long time for me to stand up here and talk to you about civil procedure. Usually you got to pay a lot of money for this kind of thing. If you have questions, just raise your hand or yell them out, and then I'll repeat them so people can hear them, and then we can just do that at any point. Our sort of research topic was looking at implementing civil procedure in some kind of computer system. We chose the Lean Proof Assistant. It's also like a full-featured programming language. So it's really just sort of a programming language in which you can prove things, which is always nice. I am just curious. I'm going to do like a computer scientist, lawyer, both kind of thing. Computer scientists, raise your hands. Lawyers, raise your hand. Okay. Both. Consider some both. Yeah, let's go. Okay. Absolutely. Yeah. Okay, so what is civil procedure? Since we have a bunch of computer scientists in the room, civil procedure is well, I like to give them like a preview of what's coming, and yeah, no, this thing, right? Yeah. Cool. All right. So procedural rules dictate the manner in which a case or controversy actually moves through the courts, or sometimes doesn't move through the courts. You have a whole set of what are called procedural due process rights that tell you sort of what rights you have when you are before a court, if you ever find yourself there. They're actually very analogous to system calls and calling conventions, because they are the way that you request resources or actions from a court. They are sometimes nice in that they afford you these procedural due process rights. Sometimes they're not so nice because they're really very complicated, and the lines are really sharp because the consequences are quite serious. So what I guess is the main problem that we're trying to address? We can pretty much sum it up with these points. All non-criminal legal disputes are somewhere in the civil justice system. Civil is the non-criminal part. The procedural rules, they were sort of created and evolved under the assumption that all of the parties before the court will be represented by counsel. We know that that's not the case. I mean, just empirically, there are lots of people that come before federal courts that are not represented by counsel. There is no general right to counsel in civil matters. And the rules are too complex to allow you or anyone else to really represent themselves. If you want to get like the sort of timeless indictment of the whole thing, you can read this thing called See Why the Haves Come Out Ahead by Mark Gallanter. It's like 50 years old, but it's all still very true. So there's a bunch of statistical work that was done by this, the Legal Services Corporation. It's a congressional nonprofit. I forget their exact title, but they did a big survey of sort of exactly who's experiencing legal problems in the United States relative to who's not being represented. Really a lot of low-income households experience civil justice matters. Almost 40% of people experience more than 5 legal problems. 1 in 5 experience more than 10. So common issues are consumer issues, healthcare, housing, income maintenance, those kinds of things. And more than half of those people said that those legal issues they faced substantially impacted their lives. So yeah, if you're in a lower income bracket in the US, it's very unlikely that you're going to have legal help from competent counsel when it comes to civil legal issues. And people who do consider going to find lawyers to help them have cost as one of their primary concerns. Legal counsel is very expensive. Things take a very long time in the courts. I mean, drafting even a motion, doing it correctly is it's quite a lot of work, and it doesn't actually get you that far every time you do it. It's sort of a very slow crawl to the finish line here. Nowadays, it's sort of, I don't know, 50 years ago, 60 years ago, 70 years ago, 80 years ago, 90 years ago, 100 years ago, 200 years ago, 300 years ago, 400 years ago, 500 years ago, 600 years ago, 700 years ago, 800 years ago, 900 years ago, 1,000 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 less crazy sounding for people that are in positions of authority or in positions to actually be heard by the establishment to just say there's a huge problem here. So the NCSC, which is another nonprofit that looks primarily at state courts, they have just said that this sort of system that we thought was running the civil justice system is not. Most people just they don't show up with legal assistance commensurate with their needs. The things that are at risk, you risk the default judgment being entered against you if you don't adequately respond to claims that have been made against you. You can be subject to all kinds of bullying by people that do know the procedural rules really well. There's all kinds of underhanded tricks that people can do to hurt your chances of winning. You might have significant costs and delays. You might run into issues with the statute of limitations. If you don't know about these procedural rights you have and you don't know how to exercise them, you're probably going to forfeit them accidentally. You might get sanctioned by the court. So entries of default judgments are actually fairly common. Because we don't have really good sort of semantic tagging of data from courts, it's sometimes difficult to even really suss out exactly what the statistics mean. We do have somewhat of a window of opportunity here. Most surveys suggest that people who engage with state courts are willing to, they're actually seeking out better engagement with the courts by means of using technology. Lawyers have largely already adopted these solutions through using paid legal research services, Westlaw, Bloomberg, Lexis, that kind of thing. So just to recap really quickly, civil litigation is extremely powerful. If you look at the kinds of things that people who are active a lot in civil courts can achieve, it can be pretty breathtaking. The sort of complexity of the system that we live in is actually sort of ramping up. Just the direction our political economy is taking means that things are getting more complex. Multi-district and complex litigation has now sort of become the norm in federal courts. And it's unfortunate because a lot of these things go to very basic questions, sort of civics questions. Who are the doors of the federal courts open to and for what purposes? It would be nice if we had a much simpler answer to that. Just to go through a sort of case study, the Supreme Court in the sort of recent years, they've taken the sort of Mills Lane approach to civil procedure, which is protect yourself at all times, and you alone are responsible for knowing the rules when it comes to your case. So there's a case called Bowles v. Russell from 2007. Keith Bowles had a habeas petition in front of a federal court. They screwed up by failing to notify him that they had entered a final judgment in his case. When he went to file another habeas appeal to get past that initial error, the district court that was dealing with his case, they wrote down a deadline that was 17 days after the current date. The actual rule, the Federal Rule of Appellate Procedure, which is a mirror of Federal Rule of Civil Procedure 6, only gave him technically 14 days. So the district court judge wrote down the wrong date on his thing. They filed on the 16th day. The case went up to the Supreme Court, and the Supreme Court said, yeah, that's too bad. You should have double checked. And they denied his appeal, and they decided that these kinds of issues are jurisdictional, which goes to another rule that says if at any time the court decides they don't have subject matter jurisdiction, they have to stop what they're doing. The whole thing's over. Don't pass go, don't collect $200. Do go back to jail, unfortunately, in this case. So this is currently the law of the land. Usually when you see something like this, if there's a dissent, this one was 5-4. The dissent is sort of couched in this like tepid language about like, well, I respectfully disagree and we have a different view of this technical issue. And Souter just said, this is bullshit. There's no reason for us to be doing this to people. This is not fair. Kind of another interesting point about this that if you're a nerd and you like looking at oral arguments for Supreme Court cases, part of the rule here, there's this weird 3-day mail provision that says if the thing you're dealing with is sent out by mail, and it contains a deadline, you have an additional 3 days. And it's sort of colloquially known as the 3-day mail rule. Paul Mancino Jr. was the attorney for the appellant in this case. So he's talking about how the 3-day mail rule is implicated in this case. So this is at issue here. And Justice Breyer says, what's the 3-day mail rule? Just a note, the Supreme Court is responsible for promulgating the Federal Rules of Civil Procedure, and he has to ask what that is. That's not a good sign of how complex these are. So this was one of the first rules that we actually took a look at, was Federal Rule of Civil Procedure 6, which talks about how deadlines and times to do things are calculated. It's the language mirrors this rule of appellate procedure. So we kind of had to start from way back at sort of first principles. We developed a date and time library in Lean that's available for general use. And from there, we implemented the algorithm that comprises this rule of civil procedure. In doing so, we discovered a couple of interesting things. This is going to be the case. If any of you get involved in like working with statutory law or anything like that, you will find just weird stuff because people are not, there's a big difference between, like a sort of pen and paper proof. And then when you go to mechanize it, you find a bunch of, things that you weren't thinking about originally. So one of the things that I would consider a bug, when you calculate the last date that your time period runs on, if it runs on a holiday or a day on which the clerk's office is closed, you get until the next day that is not a holiday or the clerk's office is closed. This computation is technically not well-founded. There's no limitation on states or the federal government or the president can declare any number of holidays they want. The district court could potentially logjam you by just saying the clerk's office is closed. So you can either just say it's partial, or you can require them to pass a proof that says, in this list of holidays, there's at least one day in any year that is not a holiday. So that one is actually, Lean has very nice features for decidability. So it's pretty easy to just say, if you give me the list of holidays, I'll figure out if there's one in there. There's another, this one I think is probably the most insidious one. This is really dumb. Dates can either be calculated forward or backward. So if the court says you have 30 days to do X, then you count the 30 days, and if it falls on a weekend or holiday, you get until the next one that is not. So you gain additional days. If what they say is this paper has to be filed no fewer than 14 days before Y, now you're counting backward. So if you count backward the 14 days, and that happens to be a Saturday, your due date is the Friday before. So you lose days that way. It's very unique. So another one is that they use local times in these federal rules. So depending on what kind of computer system you're using, you may or may not automatically get a conversion between the CST and CDT, which is daylight savings. There's also no time standard specified. In the time library that we were using, we obviously have to make a distinction between TAI and UTC and all these things. If the other lawyer is gone, but if the one lawyer remaining, if you ever have a case that turns on leap seconds, please call me because I would love to actually put that to use somewhere. There's another sort of looping thing here. This 3-day mail rule is applied after you do the adjustment for weekends and holidays. Then you apply this 3-day thing. There was a question, an open question, if the 3-day mail rule lands you on another weekend or holiday, what do you do after that? They actually clarified this in 2005. They put it in a little footnote down here. And unfortunately, they amended it when there was a 6E, and there's no longer a 6E, but that's still the footnote. This is always special. This is sort of another interesting drafting thing. So the way that law is written a lot of the times is kind of crazy. They will write something, and when they find that there's an error, they will write another thing that sort of patches it and just put them on the same page. So it's like if you wrote a function that computed dot product and there was a bug in it, and you wrote a second function to correct the output of the first one, and then someone said, well, so what you do is you just compose these two and then you get the right answer. Folks, we love it. So this is just sort of a personal note from the time library that we wrote. Last year when I was here showing something, someone asked if there were dependent types that were in type and not parts of proofs. And now I can say, yes, there are. The time thing that we used actually has this cool thing where it's indexed by the SI power unit. So if you want a signed duration that's at the second precision, you have 0. If you want like milliseconds, you put the correct SI power. And then we get to derive these, all the classes just once, and you get them for all. Yes? 4, yeah. That was kind of hard too. I'll complain about working on things that are in development is really exciting. It can be frustrating. So the whole Rule 6 thing was just sort of an aside to talk about how sort of scary dealing with civil procedure in the wrong way can be. Just to go back to my first slide here. So the initial research goals for our group, I was very fortunate to be an intern last summer at Microsoft Research with Jonathan Partsenko and Leo Demura as well. They were amazing. The whole experience was really great. The research goals, sort of in a broad sense, if you had legal software that had a semantic awareness of the rules of civil procedure, there are plenty of things now that I'll go over in a second that have sort of a syntactic awareness of the rules. The other big thing is, how do we make it useful? How do we prevent it from just being like this artifact that you can go look at and like, throw pennies into? We also wanted to facilitate sort of a combined arms approach to actually like making things useful. Formal reasoning obviously is very important. It's also getting harder and harder to deny the effectiveness of statistical methods, AI and machine learning. Although I do think you probably do need to pair them in a way that is sort of makes sense out of the whole thing. So Professor Grimmelman last year in his keynote, he dedicated some time talking about how these notions are sort of complementary. Formal reasoning, if nothing else, can supply sort of definitions and terms and APIs that people who are interested in statistical learning can use to, make sense of all the data that they're getting. So the current state of the art is you can try your favorite search engine. This is probably not going to end well. Almost certainly you'll get a really thinly veiled ad. You'll say like, I'm being sued in federal court, help. And you'll find something that says, whether this suit can be taken care of by like a motion to dismiss, depends on state and local rules. Jones and Smith Legal Services can help you with that. Talk to one of our chatbots. If you're lucky, you might find the Cornell Legal Information Institute, and you can go read a bunch of statutory law. In the public sector, so entities like uscourts.gov and various district court websites, they provide things like forms and, like I was saying, resources that are syntactically aware of what you're supposed to be doing, kind of. So they're absolutely better than nothing. We would like to help improve those, but they don't really have the semantic awareness. The same thing is sort of true for these legal research services. They have sort of the same thing, but more detailed, and they're sort of maintained more actively by groups of experts. The bright side that we can take from these things that are state of the art is that we don't have to break entirely new ground. There's already people that recognize we can make money or we can deliver value by having these things, even if they are very labor intensive. If you'll look on, like these things by Westlaw, they have these pretty large checklists and they're extremely varied. So they probably have one for each state. If you need to look up like a checklist of things that I need to include in like a deposition subpoena for any state, they'll have them, and they'll have these little marks that say maintained. So there are people that are, dedicating time and effort to maintaining just this one resource. And if you look at this, is also sort of adopted already by the public sector. There's this thing called the Chief Counsel Code and Subject Matter Directory. So the IRS has this giant army of lawyers that are dedicated to one particular section of the Internal Revenue Code. And that's their job, is just to be like, I am the house expert on the section about non-business bad debts, right? Like the Wizard of Oz for like the least fun things in the world. So this is also like, if there was a will to actually sort of do this for civil procedure, these people would probably, some of them would be computer scientists ideally if we were doing something like this. But we don't have to like create a new branch of the federal government to get motion on this. However, these things, they do still require a bunch of developer time. It is difficult. A lot of people that speak here talk about this sort of isomorphism between like, we want the code to look like the law. I agree that to the extent that's possible, we should always go for that. It is tough. It's hard. So I think just to look at, in practice, what you get from the sort of available state of the art, we can look at the pro se pleading forms that are available on the US Courts website. These are the main rules we're going to be looking at. Rule 3, these are prefaced by Federal Rule of Civil Procedure, Rule X. Commencing action is done by filing a complaint with the court. You have to state your claim for relief if you have a bunch of claims. There are more complex rules that say that you can have as many claims as you want against as many parties. You can have claims in the alternative, dependent claims. And then Rule 12 is the one, or 12H3, says that if at any time they discover they lack this particular kind of jurisdiction called subject matter jurisdiction, you got to kick it out. And that applies to the whole thing. Subject matter jurisdiction, one of the big things we looked at was this diversity jurisdiction rule, which is this insane algorithm for determining whether or not you can go before a federal court. One of the judges who had a hand in formulating the way that it currently exists said that he regrets it. It's not great. So addressing these things, this is part of the venue requirement, which is actually 28 U.S.C. Section 1391 is the venue thing. This is just to show that the lack of semantic awareness means that you can file in non-existent places. The green division of the Central District of Illinois does not exist. The basis for jurisdiction section, so they do give you the options of federal question or diversity of citizenship. The explanation they give you for diversity of citizenship is just like woefully inadequate. Like there are large swaths of diversity suits that are not covered by the description they give you. In fairness, like, what are you gonna do? It's super complicated. You can't have people filling out like reams of forms to determine whether they fit it within this really complex parameter. So questions that are not brought up, these again become immediately obvious. Like when you go to draft it in a computer, you have to start thinking about these things and you want answers to these questions. What is a citizen of a state? So this section 1332, which is the diversity one, asks all these questions. It talks about citizens of a state. It just says states. Are Puerto Rico and DC states? Who knows? There are different kinds of entities. Is it a corporation? Is it a partnership? Is it an LLC, S Corp, C Corp? When do you test state citizenship? So the form explicitly mentions, citizen of a state. Are they asking about when the thing happened that I'm suing about, or are they asking about when I'm filing out the form? They actually don't mention venue anywhere on the pro se form. That's a sort of key part of having your thing heard. They don't discuss how you actually value something like injunctive relief for the amount of controversy requirement. The answer form they give, which is another form, has sort of similar issues. I gotta speed up here. this is, if you want to go look it up, Page versus Democratic National Committee is sort of a very recent, high-profile one in which there's this massive argument about how exactly do we apply this particular subset of these diversity cases where someone is a stateless entity in a partnership. So if you're suing a partnership, in order to determine the diversity of citizenship, you have to recurse through all members of the partnership. If they are themselves partnerships or corporations, you have to apply those tests. It's very difficult to do, not that bad with a computer. And so if you screw up any of these things, those are grounds for dismissal. The filing fee in federal court is $400. There's no general tolling statute at the federal level. It's hard to get a court date a lot of times. So to address at least some of these sort of venue questions, we have another thing called US Courts that provides a type-safe API for these courts, so you will not be filing in non-existent divisions or districts or whatever else. This was one of the things that we wanted to do, and in large part we did. I would like to make some improvements. How do we describe some of these things formally? Like a big part of, if you look at like the MathLib, MathLib is the big mathematics library for Lean. They're really big on definitions. How do we set the parameters of like these things we're describing, right? What is a party? How do we describe claims between parties in ways that make sense? The federal rules use these terms very loosely in a way that's kind of hard to pin down. The deeper you get into it, you can put a formal description to it that can capture all of these different uses. Ours it's essentially just a big graph. It's a weighted directed graph. So like if A has a claim against B, that's an edge between two nodes. The edge weights are things like causes of action and claims for relief. So like I said, a lot of these things just sort of fall out in drafting. Some examples of other stuff that we found while drafting some of these laws. This is a really fun one that I wish I had more time to get into. They're really bad about saying state when what they actually want to address is states, territories, and federal districts. The Rule 6 Infinite Holidays thing. Dismissals, they're really sloppy with the way that they discuss dismissals. There's a particular example of that I have. Here it is. Oh, yeah. So this Rule 41 says that plaintiffs can voluntarily dismiss an action without a court order by filing a certain piece of paper. There's actually a circuit split now on whether this means you have to dismiss the entire action or whether you can dismiss just one claim from the action or a party. When we have this sort of more granular like graph representation underlying it, it's really easy to just talk about those things, but because they didn't, we're stuck with these sorts of ambiguities. So in terms of the research goals that we had, so the last thing I wanted to mention is a lot of these things we analyzed sort of in isolation, and we came up with sort of nice ways to discuss them, and we can demonstrate properties about them and get useful answers. Sort of the prize is composition. We want to say like, okay, these are all components of what we're dealing with here, whether it's like parties or claims or jurisdiction. How do we start composing those things? So the first attempt was to look at the docket of a civil action as a sort of program. If you don't know what a docket is, if you go on any sort of like Court Listener is probably the best free one. You can go look at like, I'm going to look at this civil action and see what's going on. The docket entries are a sequential list of like actions and filings in a civil action. So like 1 says complaint was filed. 2 is sort of a weird entry. 3, the case is assigned, attorneys appear. It's sort of a sequential list of like this happens and this happens and this happens. So what we wanted to do is treat the docket entries as a sequence of commands, like a program. We have the state of the civil action as the state as you would have in a programming language semantics. And then the procedural rules are the sort of reduction steps that would be allowed by the semantics. So think of a big step, operational semantics. Operational, or we're not really dealing with like super low level details. So just this basic outline of, you have an initial state and you have a computation. Through some application of rules, it ends up at some terminal state, right? So in our case, it's, you have the state and the docket, and then they end up in some terminal state. If someone tries to do something that is contrary to the rules, then your reduction relation gets stuck the same way that you would in sort of normal semantics. And then you can derive sort of from this step relation version, you get a functional evaluator that just errors out if you are doing something bad. I'm gonna drink of water real quick, and then I'll talk about why that didn't actually work. So the big thing that sort of threw a wrench in that, even though like you can do that, you can write that, and it's neat. I tried out for and made it onto the University of Illinois Federal Civil Rights Clinic. This is a program started by Judge Harold Baker to relieve congestion from 1983 cases. They pick 8 students once a year, and 4 teams of 2 are assigned a 1983 case. And you bring it all the way to a jury trial. So you go from like the initial stage of the case to trying it in front of a jury. This is basically everybody's first experience. Like, I'm litigating in a federal district court. I'm dealing with a judge and filing motions and doing discovery disputes. And you very quickly find out that A, you're worthless, and B, people do stuff that is not strictly legal all the time. Like, that's just the way it is. You really have to be fault tolerant when you're doing this stuff. So as an example of something that like makes sense on paper when you read the black letter law, and when you try and do this sort of naive semantic model, you just totally screwed. So Rule 4 basically just says that if you file a complaint, you have to serve a defendant with process within 90 days. And if you don't do that, it's going to get dismissed. The question is, when the 90 days is actually up and you haven't served the defendant, what happens? Let's say there's 3 defendants. You haven't served any of them, right? At the 90th day plus 1 second, a computer doesn't kick on in, some mountain fort in Virginia and just like dismiss all the defendants. It doesn't do that. They're not going to get dismissed. The judge, he might, you might see a new docket entry that he wants to have like a scheduling conference. They might file a motion first to try and get it dismissed. Nothing might happen. And instead, you just have to mark it as like, well, this might be grounds for an appeal if I'm the defendant later on. So that sort of, yeah.
If I'm a defendant and the court doesn't serve me within 90 days, then just use that and leverage that for the thing to just get the case dismissed.
Yeah, you would file a motion. So it's in here somewhere. Yeah, the court on motion or on its own after notice of the plaintiff must dismiss the action without prejudice. It's sort of another problem. It's like, okay, you filed a motion and they just don't do that, right? They're not going to say like, screw Rule 4M, but they have other things to do and they're trying to get all this stuff done. The judge is talking to the clerk. They're trying to get all of these cases scheduled and taken care of. They might first want to talk to the plaintiff and see if they have a good reason for being late. Maybe they're going to try and, I don't know, argue that you're not actually subject to service of process in the US, so therefore the time rule doesn't apply. But this sort of gets to the more important point, I think, is that how do we work within that realization? We don't know everything, right? What if there are multiple defendants? The rule doesn't really address that. What if I file a complaint and then I amend it 30 days in? Do I get a whole new 90-day period? I asked that to like 3 or 4 lawyers. The best response I just got was, well, that would be highly unusual. It's like, well, yeah, but I still want to know what happens. The thing is, though, that we do know enough to give people really valuable feedback. If you are someone that filed a complaint in a federal district court and you haven't told me explicitly that your defendant is subject to one of these exceptions, we know that you should probably serve them with process within 90 days, right? That's a safe assumption. The question now becomes, how do we use this without just saying like, well, it's all just heuristics then? And if you're a defendant, if you are being sued. A lot of times people find out that they're being sued without actually being sued in the process. If you haven't been served within 90 days, we can't just say, well, you've won. There's still stuff you have to do. It might not work out entirely in your favor, but we would like to be able to tell you, like, listen, you can get a massive advantage. The best move you can do at this point is to file this motion to dismiss. Time constraints prevent me from going over that in more detail. So, learning from our mistakes of, I'll be nice to myself and I'll say, learning in the light of real world experience of like these sort of controlled chaos of federal litigation. A couple of things. Long range inferences, the kind that you would usually take from this sort of like very nice semantic model that you can like step through the whole thing, not actually that useful. What you have at any given time is like, let's say, time t, right? And there's this state, the parties are going to do a bunch of stuff, and then the authority presiding over the case, which is a judge or a magistrate or whoever else, they're just going to tell you what the post state should be in the real world, right? But you do have a bunch of like really good guesses you can make based on the rules. And if nothing else, if the post state they give you doesn't comport with the rules, your rules can tell you that, you should probably start thinking about this as grounds for appeal maybe, or call the judge, maybe you need to get something cleared up. So we're actually not as interested as I originally thought in getting like really long range inferences. We also, I wrote a bunch of this stuff to sort of like, here's the correct answer. If you give me like 100 different parties, you're suing the largest 3 partnerships in the United States, here's the diversity jurisdiction analysis. Even if it's the right answer, you can't just give me the right answer because it's terrifying to look at that. Even if it has been like, verified relative to some specification, I want to know your reasoning. I want to know like alternatives. Just show me the whole like execution trace, all the different paths it could have taken. More information is usually going to be better from the user's perspective. Assigning these sort of like deterministic consequences, as in the Rule 4M thing, is really going to be very difficult. But again, not that high in terms of utility. What we would really rather have is like the simple thing. Give me the simple thing of like, you gotta serve the defendant within 90 days. And then also, there's a low value in hindsight on really correctly determining the outcome of any given step because it's gonna be given to you. The judge will tell you what he wants to do. It's not a mystery. So you will get this information eventually and in enough time to like do something useful with it. So it's not all bad. It's just that like we thought it was this and it's actually sort of this direction that we want to go. Yes.
A quick question. Wasn't there a recent case that got thrown out on diversity of jurisdiction from federal court after going all the way to the Supreme Court?
Probably because that happens all the time.
Okay.
Like diversity of jurisdiction is one of these ones that like really, they will have cases that have gone for like years and years and years, and they'll just say like, they didn't have jurisdiction over this. So I'm sure you're right, yeah. So the sort of closing remark, the model that we're going with now is that all of the parties involved in a civil action have just a score, right? If you want to go like a unit score, we'll say like -1 to +1. We're only thinking about one state at a given time, and application of the rules just gives us a new set of deltas for scores. So if you've done something bad, it's usually pretty easy for us to say that like, this is bad and this is good. You just get a bunch of new scores that correspond to new information, as opposed to having like a precise set of consequences that you get. Under this new understanding that like the starting and ending state in reality are going to be given to you by the facts. What we're interested in is like these sort of speculative positions of like, well, what can we or should we be looking at from this point in time?
Hey, Chris,
Yeah.
do you have a final slide to wrap up real quick?
Yeah, I do. I want to complain about law school for 1 second. One of the reasons why probably you have a hard time finding like interdisciplinary people to study with, the way that law school works in post-graduation employment, there's sort of this diminishing returns thing. It's like a sigmoid curve. Like the more time you spend, you get more and more and more expertise. This is probably like a balanced outcome, right? Law school wants you like as far on this end as possible because like being one rank higher in your class rank is going to get you like better employment outcomes. If we want to encourage more sort of interdisciplinary study, you know, if anyone listening to this or in the room is involved in legal employment, like maybe putting less emphasis on this and like, you know, who's doing interesting things that could potentially add value to our practice outside of, you know, getting that one additional class rank or whatever would be good. There's also this sort of difference in people's like time horizons for publishing research and everything. But yeah, so we had a lot of success in analyzing like particular questions and interesting things and finding bugs. Compositionality is sort of the thing that we'll be more interested in going forward. But yeah, thank you very much.
So while our next speaker is setting up, do people have questions for Chris?
Hi, I thought that was a fantastic talk. Thank you. So I wanted to, so the motivation for formalizing the pleading. So I'm, you know, wondering whether the friction in, like, it was really interesting to see the pro se slides. Because it's just like a disaster. That GUI is a disaster. Like it's not usable. But in some sense, it's designed not to be usable because you don't. I mean, the federal courts don't want pro se litigants, and they're trying to raise the stakes to control their docket. And I think the same thing in terms of like ambiguity in regulation. Those are often highly intentional. So the question is like whether you think those, like, is it you want to do this because you want to see what it looks like, or you think from an access to justice perspective it's way better if more people have you know, are able to file pro se claims, and politicians shouldn't get away with ambiguous legislation? Yeah, you see what I'm asking?
Yeah, I wish I had a lot more time to answer that one. So the pro se thing, most people that appear pro se are defendants. So I know that like it's my fault for focusing mainly on the complaint, but most people that show up without representation are just being sued, which to me, I mean, that's sort of out of necessity. Like whether federal courts want pro se litigants or not, if you get sued and you don't have money to hire representation, you have to show up as a pro se defendant. Yeah, like I said, it's sort of my fault for focusing more on the complaint. I personally, I would like to empower, you know, pro se litigants on the complaint side. Because the exact question that was, am I in favor of pro se litigants on the complaint side?
Like, is it because you think it's better that people have that more people have these tools?
Yeah.
These ordinances.
I think okay.
So I'm going to jump in real quick to summarize because I had some similar thoughts. I think this is a great conversation that we can continue perhaps after the session. But basically this observation that this talk began with a discussion about equity and access, and then a discussion of ambiguity and inconsistency in the law. And it seems to be that at least in American civil procedure, that there is a tendency to actually prefer ambiguity because it's something that takes power away from the people. If you have a system, it can help people. And so this can also be phrased as a sort of security question where if you look at adversarial behavior in the system, it seems that there's an incentivization to make the law not comprehensible. And so proving aspects of the law using lien, there seems to be no protection against like encoding things that are emergent and contradictory, thus creating a system that eventually prioritizes performance art in the courtroom rather than actual like solid legal reasoning. So that's what I understand this conversation to be about. Food for thought.
I like that answer. The one thing I will very quickly.
Very quickly, please.
If you as the federal courts want to say that we don't want pro se litigants, I think it's not legitimate to do that by giving them crappy tools. You should just man up and say, don't come here. The end.
Okay, thank you. Okay, so next up is Teresa. Do you want to say your last name?
Novotná.
Novotná. Yes, we're going to get you set up with the microphone, giving her talk today on designing an experiment for comparing user interfaces for legal formalization.
Is it correct? Yeah. Should I? Yeah. All right. It works? Yeah. Okay. Sorry. Okay. Good afternoon. I would like to welcome you to this presentation, one of the last this day. So thank you for staying so long. My name is Teresa Novotná, and I come from Masaryk University in Brno. And I'm a lawyer, so that's a bit disclaimer if, like in the case of some more technical questions that I won't be maybe able to answer fully. And I am presenting this on behalf of our small team with Tomer Liebel, who is a researcher from the University of Luxembourg. Yeah, the topic is designing an experiment for comparing user interfaces for legal formalization. Yeah, this is the outline. I will just go straight to the first slide. So the context of this research, which is work in progress research, is that we were developing the normative AI tool, soon to be DeLeak AI, whatever, and it's based on annotations of different parts of the text and providing the logical relationship between these parts of the text. Yeah, our goal was to come up with like very practically oriented tool, which will be very simple and easy to use, so that it can be evaluated by lawyers. And yeah, so our approach is very user oriented. So we are emphasizing the interaction between lawyers or users and the interface. But during this ongoing research, we decided to take a step back and ask, because of course we know about all of the other approaches that were also presented today and that are in the research area. So we decided that we would like to come up with an objective evaluation methodology for comparison of the recent methods and approaches, and for like to find out what are the weaknesses and strengths of different approaches, and what are the actual trends, and where we can inspire ourselves, and etc. And also whether our approach will could be used, yeah, in this context. Yeah, so that is the motivation. So there are many approaches, and usually in the presentations or the papers or documentations, they are narrowly focused on specifically legislative X or even part of the text. They very often lack the evaluation part in the end, or it's just very short. So it's really hard to, I don't know, compare it to some other approach. And yeah, so we would like to come up with the objective methodology, which is a very multidisciplinary issue, of course. So this is the problem, and it is how to evaluate in case of evaluation of legal formalization methods. And we are very focusing on the practical interaction with the user. No, sorry. Sorry. Yeah, in our previous research, we decided that we will go through the methods that are recent and that are used, and we will try to focus on the information, whether and how they are evaluated, and what are the common issues that are dealt with in this research, and based on this literature review, we extracted 4 essential parameters. That are not very surprising, but those are the ones that we would like to, that we find crucial for to take into consideration and to evaluate when talking about or when designing legal formalization method. And they are correctness of the legal formalization, transparency, comprehensibility, and multiple interpretation support. I will go through them one by one in a minute. And the proposed evaluation methodology that we find optimal is legal experts evaluation, which is manual assessment of the interaction with the tool or with the method. Yeah, so correctness, that's like the crucial point, right? Yeah, that's the mapping between the legal rule or the text and its representation and logics. The thing is that there's an expectation that there should be one correct logical representation that is then used for the automatic reasoning and all the following things. But how to find it, and the question is even whether it exists, because in some cases it doesn't necessarily need to be the case. So we decided to take the analogy from the Hart's theory of soft and hard cases. Although the theory is focused on cases that go to court, and basically it means that it's supposed to be that the majority of the cases are easy and they should be solved by like very straightforward interpretation of a legal rule or the law. And there's a small part of cases that are harder, that are abstract, and they require much more knowledge and thinking about the case, and like more complex interpretation of the law that is applicable. So based on this, we kind of decided to say that the correct formalization of a certain legal rule is the one that like the majority of the legal experts that we employ in the experiment will agree on. So we will have like a broad consensus of on one interpretation. So we will accept it as the correct one. Of course, like in the context and the time that we do the interpretation or the experiment. Transparency. That is something we call the relationship between the legal text and the logical formulae. Because we also wanted to reduce the number of people or researchers working on the formalization itself. So the idea is that if there will be very transparent way of how to see what was the original text and what is the logical interpretation, and if it will be very clearly visible, then we do not need another expert like logician or computer scientist who will explain this to the lawyer, so that the lawyer can itself evaluate the correctness of the logical representation. So yeah, that's the transparency. It's a main feature for reducing the number of experts involved, which is also, of course, related to reducing costs and time and all of these other things that we need during the experiment. Yeah, and the transparency should be evaluated from the regard of the simplicity. So it's like comprehensible and simple. Comprehensibility is a feature that is related to the user interface or the thing that is presented to the lawyer who is doing the legal formalization. So it can be expressed in a question of how cognitively demanding is it to formalize the legal text and understand the result. We think that it's very crucial that the method or the the user interface is as friendly as possible and as simple as possible. But of course, there needs to be a balance between the simplicity, so that it's like it can be used by lawyers without any further help of other people involved. But of course, it also needs to be complex enough to involve all of the different legal relationship or different legal sources that may influence the certain situation. So yeah, finding the right balance between these two is a crucial point of the comprehensibility feature. And the last one, that's multiple interpretation support, which is our answer to the hard cases, or the cases that are not very straightforward and that are harder to interpret. We think that the legal formalization tool should be dynamic, so that like the change of the interpretation is easy, and it should be it should allow to include more interpretations in case that the situation or the legal rule is not is controversial. Yeah. And also, from the point of view of temporal and interpretative development of meaning of legal text, it should be easy to change these interpretations. Again, this is the question of balance of granularity and complexity versus simplicity. So we want the interface to be easy enough for use, but we also need it to be complex enough to be able to include different legal sources and different influences, maybe like interpretation in legal, in co-decisions, or I don't know, some other support legislations, etc. So yeah, again, the question of balance, and yeah. How we want to do, how we want to find the tools to be evaluated in the experiment. We wanted to choose very objective methodology. So to find a search query, to go through Google Scholar and take everything that we get, or yeah, that's it. But that's something we will do. So when we start the experiment itself. So yeah, that's just for now. And this is the final part. Now I'm going to talk about how we think we should design this human evaluation experiment. So we would like to gather ideally a group of legal experts, and we would like to evaluate with them the user experience with the different tools that we will get from the query, or from the selecting of the tools, and yeah, and they should be presented with the tools, and they should perform some tasks with them, and then they should evaluate it. What is very important is that we have to select coherent and complex enough section of regulatory text, because we know that just a short section doesn't really tell us a lot. But of course, if it's like too complicated, then it will take a lot of time, and there will be probably bigger differences in the interpretation that can be hard to interpret in the end. So that's quite a crucial point, actually. Also, we want the text to include different legal modalities and different legal institutes. And of course, we have to provide the evaluators proper instructions and guidelines. Not all the tools have them. We will probably make them ourselves, but we are not the authors. That is something that we need to deal with. Yeah. And these are some last remarks that we have from, yeah, because yeah, like human evaluations, that's a very multidisciplinary thing. So these are some remarks we have from sociological surveys and questionnaires. So we would like the size of the expert group be as big as we can get, but of course that depends on the time and cost and everything. The composition should be variable. Yeah. Then we have to, of course, pay a lot of attention on the questions. They should be on all of the parameters that I mentioned, and they have to be non-introducing. That's quite important. We want the rating to be on a scale because it's the easiest way how to interpret the results of the experiment. That is quite interesting. There should be always an even number of options, because if people rate something on a scale and they do not know, they choose the middle point, and that doesn't really say much about their choice. Yeah, and we would like to also do the inter-rater agreement measuring, because we want to know whether the evaluation is highly subjective. From my previous evaluation experiments I did with different legal information retrieval methods, I found that the inter-rater agreement was quite low, so that the evaluation of the lawyers wasn't highly subjective. But of course, it was different methods. So let's see. Because the subjectivity of the evaluation, of course, has an influence on the interpretation of the data from the evaluation experiment. Yeah, the future work is to actually perform the experiment. That's for us, and that's all. Thank you very much for your attention.
So there was a question online asking about your methodology in choosing to minimize the number of participants rather than getting more participants for, over less time. Could you address that to the person who asked?
Yeah, sorry, can you say it again? Or because, so what was the
question was, why choose fewer people for more time than more people for less time?
Yeah, okay, why more people? Okay. Yeah, I do not know the answer from my head. It's usually about the balance between the time and the cost we have, and of course the time that we can give to one legal expert evaluating the tools. There's the thing that, of course, we want the evaluation group to be as big as possible, because then the results are more significant. Yeah, but I do not have the straight answer to this, so we have to find a balance. Yeah.
Thank you for a very nice presentation.
Thank you.
Very, very relevant. So we had a PhD student doing these kind of user evaluations on the tools we developed.
Okay.
So that might be some inspiration.
Yes.
And I think, one thing you should be careful about is whether you evaluate the tool or the method, or how well the people were trained in using the tool. And so there are a lot of pitfalls.
Yes.
And then I guess also for the literature review, maybe also look outside the legal normal sources, because there might actually be people in the computer science domain publishing somewhere else who are doing stuff like this. So, but I'm happy to talk more. I think there's some really good criteria you have set up. So
yeah,
looks
thank
good.
you. Yeah, I would love to definitely continue because the evaluations are really my thing. So.
This will be more common for the community, since it's the last talk. Maybe we can also talk about the community. And it is about evaluations in other fields, especially in the formal methods. So for example, maybe like 10, 15, it's hard to say when, there were several tools for software synthesis, and various people were trying to work on the software synthesis. And then the community sit down and says, okay, we want to be able to evaluate our tools. So they kind of agree what will be the input format. And then actually you could see, like how you can get better comparison of the tools, because it was, it's kind of I mean, I got like relatively good overview of what is happening in the field exactly from the course that we were teaching. And very often tools could not be compared. But, you know, like if there would be some joint intersection of which you could say, okay, this is what every tool that we expect is able to do, that's required input format, then you would actually get a better understanding what is happening. It's not only synthesis. I mean, set competition has their own Dimex format. Then there is in the SV comp is for the competition of verification tools. So there are various input formats in which actually, you know, like formal methods and verification community are, you know, like are competing. So it would be interesting to maybe, you know, like to hear. I mean, yes, I know that initiative right now, those tools look like there could not be combined, but if you look like, you know, like initial state of the synthesis tool, everyone was pushing their own synthesis tools, but yet somehow people managed to reach common agreement. So it's maybe not the question, but
no, but that's a great comment. Thank you
for the community as a whole. Thank you.
Yeah, thank you.
Maybe just to add to what Ružica said, it's also the definition of benchmark suites, right? So examples, case studies that different tools can be compared on.
Yeah, thank you.
If you want to be involved in preparing this benchmark for the next session of ProLaLa', please contact us.
Yeah, along those lines and along those lines, I'm wondering how much for us as a community, this might be part of an HCI question rather than a numbers or a semantics benchmark, and maybe something to think about for future iterations of the workshop is try and reach out to more people in the HCI community and do things like run more user surveys and get actual feedback from people on our tools.
So any more questions? Okay, let's thank our speaker.
Thank you.
So our next penultimate talk of the day is by Jason Morris, who will be talking about blocks, which is user-friendly something ASP.
Can you hear me okay?
We hear you great.
Great. Let me see if I can get my slides up for you.
That's why I said penultimate. Yeah.
Is that working for you? I think I heard a yes. So I will go ahead. Hi, everybody. My name is Jason Morris. I'm the CEO of Lexpedite Legal Technology, and I'm currently engaged as the Director of Rules as Code for the Public Health Agency of Canada. And that's my email address, and I would like very much to hear from anyone here today about any of this or anything else. I've just been fascinated with everything. So I'm going to be talking about blocks. Blocks is user-friendly something for rules as code. And the background is that I've been working on blocks since the start of 2021 with a group at the Canada School of Public Service. And that is a central agency in the federal government of Canada. That's kind of like the internal learning and teaching department. And they have a subsection called PSX, Public Sector Experimentation. And that group has been doing rules as code experiments for quite a few years at this point. And I've been helping them since 2021. And as soon as I joined in, I started redeveloping the blocks software for their purposes. And what they're aiming at is rules as code in the public sector administration sense, which is using semantic representations of the meanings of laws and regulations in order to help at every part of the policy life cycle. So from policy design to regulatory drafting to systems implementation to static analysis after the fact, and implementation like compliance by private actors who are regulated entities and the whole thing. So there's a lot of variety there. I've been trying to develop blocks as a way to get subject matter experts who are not programmers involved in both writing the code and reading it and validating it and testing it as much as possible. And so it's a prototype, still early days, but we're kind of making good progress. It's currently being used in 2 projects inside CSPS, one of which is a systems administration project. Another one is a legislative drafting project. And there's a couple more projects that we're expecting to onboard in the next couple of months. We've only been using it with actual non-programmers writing the blocks encodings since about August. So it's very early days, but I'm happy with the progress so far. It uses Blockly, which is a Google library to do the user interface. And that's a tool for educating children on how to write code. So if it works for kids, maybe it'll work for lawyers, is the thinking. And I can say that because I am a lawyer. And it uses SCASP, which you've already heard about today, as its reasoning language in the back end. So the process of using blocks is in 4 stages. You give blocks the legislative text, then you encode the legislative text section by section. And that encoding involves 2 parts, the first part being the ontology and the second part being the rules. Once you have done that, you go through the process of validating your encoding, which is really right now where we're getting where the subject matter experts are getting involved. And then you deploy your encoding for whatever it is that you were trying to do. And ironically, in the legislative drafting process, a lot of what you were trying to do is actually learn the things that come from trying to encode it. So there may not be a step 4 in the legislative drafting process, but often you're trying to build a piece of software, or you're trying to do some systems simulation, or you're trying to automate something. So that would happen in stage 4. So I'm just going to show you the current system, and I'll just get someone to confirm for me that you can see this on the screen, the Blocks website. Oh, it looks like it's there. Okay. Let me know if there's any problems. So I'm going to show you the Old Age Security Act test, which is the example that was used in the paper that was just this morning uploaded to the website. So you can take a look at the PDF later if you'd like. So step 1 is getting the rules, the legislation in. For that purpose, I've created a markdown-like syntax. It's called CLEAN, Canadian Legal Enactments in Akomo and Toso. So this is basically a markdown-like syntax that generates Akomo and Toso in the background. And so you just type it in a plain text. This is not as user-friendly as I would like it to be, but it's a lot more user-friendly than trying to write Akomo and Toso. So good enough for now. So you do that, and you've got the text of the act in there with its structure. And then you go into the code editor, and the structure of your text becomes the structure of your code. So you can see that the text of the law gets converted into a nested tree of sections. And if you have need, you can use CLEAN to add arbitrary additional sections in here wherever you want them. And then the idea is that you can go section by section, encoding the semantic meaning of each part of the law in the blocks language on the right there. And there was some talk about structural isomorphism before. This is an example of wanting to keep the smallest possible section of legal text and have a one-to-one relationship with the smallest possible section of code. The advantage being it's easier to review, it's easier to change when the rules change. But this is also a very familiar interface for people who are used to dealing with the legislation itself. So today we're just going to take a look at section 3.1a, which is subject to this act and the regulations. A full monthly pension may be paid to every person who was a pensioner on July 1st, 1977. And so I said there are 2 parts. You can see the 2 parts are represented in these 2 blocks. The first one sets out the vocabulary for this section. So there is a category called person, and a person has attributes pensioner July, which is a true or false attribute. And it appears as it is true or false that the person was a pensioner on July 1st, 1977. So you define categories and then attributes, and then you give those attributes a natural language representation. So if we wanted to say that a person had an attribute was called best friend, we would just drag this in here and say best friend, and best friend is a person. And then we could copy this block and say we're going to say the target person is object's best friend. And then if we save that, you can see that this has created in the user interface a new block that's available here. And so the actual coding happens in the natural language and in the blocks. The natural language makes it a little easier to read and maybe a little easier to write, hard to know. And then the fact that it is in natural language makes it easier to read for people who aren't writing the code. But that natural language also gets used by SCASP in the explanations. So you can see the second part here is encoding the rules. And here what we said, if there is a person and that person was a pensioner on July 1st, 1977, then we know according to this section of the Act that the person qualifies under Section 3.1a. And that conclusion is being used elsewhere to conclude whether or not they're entitled to a pension. So that's the basic idea. You step 2, you encode the vocabulary and you encode the rule, and you've got this nice little block format that will not allow you to put things where they don't belong. So a data type like time will fit up here, but you can't put it in there. It just clicks away. So that's how that works. And then you want to validate. Now I usually go section by section and validate each section as I'm going. We'll skip that process and skip to a more generic validation in the interests of time. So this is a test for the generic question of, does it legally hold that the person is eligible for a full monthly pension or not? Both the true and false, eligible, and the person are variables. So that's your question. And then you've got the scenario editor, which is, we've made a bunch of changes to this just in the last 2 weeks to kind of minimize the things that are displayed. So we've got this view feature now that allows you to exclude attributes that are not going to be useful to the user, and even sub-attributes of specific objects, if that's helpful. So we can see we've got the category person here. We can add a person, let's say Jason, and we know that whether or not I was a pensioner in July of 77 is what's relevant in 3.1a. We can say that that's true. We can say that that's false. And then we can run the code with those facts. We can also get rid of this, and we can use this unlock button to say that SCASP can create an abducible predicate here for whether it's true or not that Jason was a pensioner in July, and reason hypothetically about it. So now that we've created those facts, we click run. And this is going to take a few seconds for a couple of reasons. One, I've discovered the way that I've implemented diffusibility is computationally inefficient. And so I'm going to be coming back to that in the next few months to see if I can speed that up. But also this is alpha software, and I'm a lawyer, not a programmer. So I need everyone to keep their expectations quite low. Is that enough stalling? Is it going to give me an answer? There we go. So we get 2 answers back. And remember, the question was 2 variables, the person and their eligibility. So we've got 2 answers, one where I'm the person and eligibility is true, and one where I'm the person and eligibility is false. And then it will give you as many explanations as it finds. Those explanations are in natural language, and they are linked back to the text of the original act that was used in the reasoning. And you can see here it says that it has abduced that Jason was a pensioner on this date. And so it's assuming that that was true, then yes, Jason is entitled. And then over here, you can see assuming that the same thing is false, then it is false that Jason is entitled. So if that is the only variable that you're making available to the reasoner, it can find a way of getting both a true answer and a false answer with regard to Jason. And because this is using a predicate type of logic, it's different from tools like DataLex, where you really can only deal with one entity of each type at a time. Here you can ask the question about as many people as you want, and the reasoner is perfectly happy. In an expert system, what you would like to know is what's relevant to the conclusion that you're seeking. And Blocks has the scenario editor here has a little demonstration of that, in that if you set something to possibly true, possibly false, and then run the query, and it turns out that that element was in fact relevant in one of the explanations, then it will show up as highlighted in the user interface to let you know this is a thing to which a concrete answer would give you a concrete or a concrete input would give you a concrete answer after the fact. So that's kind of where we're at. It's available at dev.blocks.com right now. In fact, this code I think is publicly available, so you can try this actual interface yourself. And I would absolutely love to get any kind of feedback or questions from the people here today. And I think that's my time.
Do you have any questions? Excellent.
Thank you for a very nice presentation. I think it's really cool you use this graphical program language, and also you keep the natural language relationship. So just a practical, if I wanted to throw this after students, I mean, can they play with this, how to use this graphical program language as also, or?
Yes. Yeah. In fact, you can. So I have to give the caveat that the dev.blocks.com site is it gets deleted and reinstalled very quickly. So I can't promise any continuity of data, but there is a way to register for an account, and you can create projects based on examples. And one of those projects, called the Wills example, actually has a tutorial inside it that will take you through the interface and kind of give you the basics of how to use it. So I encourage that as a place for people to start right now. The tutorial is also very alpha, if I could put it that way. It needs a lot of improvement, but it's kind of I'm very much following the.
Oh. Back on stage.
Oh, sorry, did I get cut off? I was just saying the tutorial is very alpha, so it's not fantastic, and I want to improve it, but it is available if you have students who are interested. And I would be delighted to help if anyone is interested in taking a look with interested students. That's right up my alley.
Great.
Okay, so everyone, go to the website and help do some load testing and some alpha testing. So thank you, Jason.
Thank you very much.
Round of applause. And now we have our ultimate talk by someone online about criminal law in Catala. I don't know if I pronounced that right. Sorry. The suspense.
Hello? Okay, I can now start my
Hear
presentation.
you. We can hear you.
Uh, okay. Can you see the slides? Hello?
Yes, we can see the slides.
Okay. Thanks. My name is Yue. I'm going to talk about my experience of formalizing criminal law using the CATLA programming language. I worked on this project for 4 months, and I come from a computer science background. Let me paint the background of the technical background of this project. It is criminal law, and criminal law has its own complexities. It has its longitudes and latitudes. On the one hand, the criminal law defines many crimes, and on the other hand, it defines a variety of penalties for each crime. So in this image on the left-hand side of the slide, I use horizontal lines to represent to denote the different kinds of crimes. For example, there are DUI offenses, there are theft, murder, drug offenses, etc. And I use the vertical lines to represent possible penalties associated to each crime. They have intersections between the horizontal line and the vertical line. So a complete formalization of the criminal law should cover the entire landscape. It's all the intersections between all the horizontal and the vertical lines. But this is a very huge work to be done. So we should start from something small. So there are partial formalization of criminal law. Oh, by the way, by saying a formalization of criminal law, I mean using the CATLA program language to paraphrase the law and to write a piece of program that accepts input and produces output that in compliance with the law. So partial implementation we can follow either a horizontal line or a vertical line. For example, we can select a particular kind of crime, let's say murder, and we compute all possible legal consequences of murder. For example, the probation, fine, and prison terms. Alternatively, we can also follow a vertical line. For example, we can focus on parole, and so that the program, given any kind of crime, can compute the parole rule related to this crime. I tried these two approaches, but they are not suitable as a starting point for formalizing the criminal law because they are still too complicated. So finally, I settled with a minimal challenge, which is focusing on the DUI offenses and focusing on the fine, which is one particular intersection between DUI offense and fine. That is the work I'm going to present. But before that, let me introduce some background on the CATLA programming language. CATLA is a language for annotating legal text, and the program is in general interspersed with the lines of the text, and it features making competing definitions. By competing definitions, I mean the value of the same variable is defined many times in many different places, and the definitions may be different. We see this very small snippet of program on the left side of the screen. There's 3 equations. The first one is def x equals to 1. The first equation defines the variable x to be 1. And the second equation says that if another variable y is greater than 0, then x equals to 2. And these two definitions are independent. The first one says x is 1 absolutely, and the other one says if y is 0, then we know for sure x equals to 2. And this you can think of these equations 1 and 2 as two authorities making a claim on the value of x. And if we consider the situation in which y equals to 0, then the first authority says to you that x shall be 1. The second authority says if y is greater than 0, x shall be 2, but it does not mention what happens if y equals to 0. So in this situation, when y equals to 0, the first authority gives you definition, and the second authority says that in this situation, x is not defined. So you're receiving a conflicting messages from different authorities. This is a competing definition. And we can resolve this definition by an implicit rule in the ProLaLa' programming language. This implicit rule says if one authority tells you this variable has a value and the other says this variable is undefined, then you should regard this value as being defined because it is regarded as being eagerly seeking a value. And in this situation, when y equals to 0, the first equation gives you the final value. And if we consider a second scenario in which y equals to 1, then again the first equation tells you x equals to 1, and the second equation tells you x equals to 2. This is again a conflict, and this conflict is resolved by a priority declaration. This is equation 3. This equation is provided by the programmer, saying that the priority of equation 2 is higher than the priority of equation 1. So when y equals to 1, the equation 2 takes dominance, and the 2 is taken as the final value of the variable x. So this is the basic idea of the ProLaLa' programming language, and making multiple declarations or definitions for the same variable, and these definitions may be conflicting with each other, but the programmer provides priority rules, and under any scenario, the value of a variable shall be unique based on the definitions and the priority rules. This is the basic idea of the ProLaLa' programming language. And now we see how we're using this language to model to write a calculator for calculating the fine for a DOI violation according to Florida statutes. We choose Florida statutes because our legal partners happen to come from Florida, so we have the support from them. And in this diagram, in the boxes are excerpts from the code, and the arrows represent the exception relationship. If there's an arrow from one box to another, it says the source of the arrow is the exception to the target of the arrow. And all of these boxes contain something similar. For example, they all define a variable named fine. For example, in the first box, it says definition fine equals DOI fine minimum is 0, maximum is 0. This is the default situation, which says the person shall not be fined. And then it has 5 exceptions related to the green box by 5 arrows. And these 5 exceptions are mutually exclusive, saying that, for example, let's say the first yellow box, definition fine under the condition the person is a violation of subsection 1 and first conviction consequence equals minimum fine $500, maximum fine $1,000. So the person is in violation of subsection 1. The subsection 1 says person commits offense of driving under the influence if he has or she has a blood alcohol level or breath alcohol level of 0.08 or more, or his normal faculties are impaired. But it's a distinction between first conviction, second conviction, third conviction within 10 years of the second one, third conviction out with 10 years of the second one, and fourth or subsequent convictions. So there are 5 different exceptions, and they are mutually exclusive. Means when one exception holds, it is impossible for the other 4 to hold. And each of these 5 situations have their own exception. For example, for the first one, which is let's say the red box, and the first red box saying that the fine under the condition the person is in violation of subsection 4 and the first conviction. So the relationship between subsection 1 and subsection 4 is the subsection, you have a violation of subsection 1 if your blood alcohol level is greater than 0.08, but if you violate subsection 4, if that blood alcohol level is not only above 0.08 but also above 0.15, so it's a more is an aggravating factor. And the ProLaLa' language can capture this sort of exception, default exception reasoning. And in the lower right bottom of the slide, I use a small tree structured diagram to capture the essence of the logical structure of this program. So at the very top, we have a default case, and it has 5 branches, which represent 5 different mutually exclusive exceptions. And this is the second tier of the tree, and the third tier of the tree. These are the individual exceptions to their different. It's 2 levels of exceptions. Okay, we have now introduced the ProLaLa' language. We have now seen how ProLaLa' is used to model the logical structure of the legal text. And let's see some key findings in this experiment. And this I use this table to capture all possible input and output to the program, to the formalization. And we assume that a blood alcohol level of 0.10. That means the aggravating factor does not apply. And we have this table has the first row is about damage. There's no damage or damage to property or light injury to person, or there are serious injury, death, or death without aid. And the first column says there the DUI, maybe the first DUI or second DUI or third or fourth. So there are 2 dimensions to evaluate a DUI offense. And the green area of the tables are the places where there's no ambiguity. There's a clear priority defined by the statutes. And the gray area represent those situations which are not explicitly. We see, for example, we take any one cell you'd like. This cell contains all of these cells have the same format, saying that by 2A the fine, by section 2A the fine is what, and by section 3 the fine is what. And these are possibly conflicting results returned by the calculation. And ideally, these conflicts should be resolved by some priority annotation, or by the implicit rule that if it is undefined, it should take a value. But in the gray area, the 2 results cannot be merged. For example, if we see, I use the dashed red borders to highlight some of the confusing cases. For example, if we take the second DUI, if this is your second DUI and you damage some property, and by the clause 2A you have for a second DUI, you should have a fine of $1,000 to $2,000, and by subsection 3, if you damage to property, this is a first degree misdemeanor. You should have a fine from zero of maximum $1,000 fine. This makes me rather confused, because a second DUI technically is a misdemeanor, because its prison sentence its jail sentence is no more than 1 year, but its fine is from 1,000 to 2,000. Well, in Florida, the maximum fine for misdemeanor is 1,000. So for the second DUI, its prison sentence its jail sentence is on the level of a misdemeanor, but its fine is above the level of misdemeanor. This is one thing, and the second thing is how this person shall be charged if he damaged property and in his second DUI. Will he be charged? Shall he be charged with two crimes or just one? And what makes it even more curious is if I didn't damage anything, I will be fined from 1,000 to 2,000. But if I damage anything during my second DUI, it is possible that I will be charged with a misdemeanor and I will be fined less. So the more damage I cause, the less I'm fined. This looks strange. And a similar situation exists when it is a third DUI out with 10 years of the second one and is damage to property or life injury. So in summary, I used the CATLA program, CATLA language to try to formalize the DUI law, and the user shall provide some basic information, and the program computes the fine. So the goal of the project is very simple. I gave the user provide some preliminary information. For example, when is your DUI? Do you have any prior DUIs? And when is the date of your last DUI, if applicable? And what is your blood level? So this kind of basic information, and the program can just try to answer one question: what is the fine? But even this sort of seemingly straightforward task cannot be easily programmed due to these ambiguities or unspecified priorities. Another question I have when I doing this project is there's some construction rules concerning whether, for example, you can consider that the second.
I'm sorry to interrupt, but we're already very over time. Could you please wrap up in the next few minutes? Thank you.
Sure. Well, in short, I'm just discovered some situations that I need some help from legal experts in order to resolve. And the output of the project is a simple calculator, as I described earlier. The user provides some basic information like the date of the offense and blood alcohol level, and the calculator shall compute the fine associated with this crime, with this DUI offense. But there are some ambiguities not resolvable by a non-expert. This is the talk. Thanks.
Okay, thank you. We have time for maybe one or two quick questions.
Hi, thank you for the talk. Always interesting to see the legal texts kind of as examples. Did I understand it correctly? You found that the exception structure was always a tree structure, or in this case, but does it mean that we can expect that this will be the case in all law texts? Or
So the exception structure is not always a tree structure. It can be a graph structure. It means there's one rule is an exception simultaneously to multiple other rules. But the Cutler program language has a limitation on the structure of exceptions. Currently, it only supports exception. Means one definition can only be an exception to one other definition. It cannot simultaneously be an exception to more than one definitions. So this is a limitation of the language. But
Okay, thank you.
oh.
So it sounds like no more questions. Yeah, then I will cede my session chairing duties to final remarks. And also thank the speaker, everyone.
You want to say something? You want to say something?
Yes, it will be quick. So thank you very much for having attended this day. I hope that you all enjoyed the presentations and it gave you ideas for a new project that you could submit to next year's edition of ProLaLa'. Thank you very much, everyone, and have a good night.
Good.